Am I on the record? All right. All right, we're set for several things today, including a status on 2008 CF 13331. Mr. Baez, Ms. Lyon, you want to go forward on that?
Yes, Judge. May we approach the podium?
Yes, please do. And as I mentioned, whenever we're going to speak today, I need to have you do it at the podium. Go ahead, sir.
Judge, at this time, my client would be entering a plea. We'd be pleading to the court. I believe Your Honor has the plea form in front of him.
I do. Anything else? And this is simply a plea to the court, correct? And then both sides are going to argue for what you think is appropriate?
Correct. What I figured we would do is, if Your Honor would like to begin with the colloquy afterwards, we can. The defense is going to be waiving a pre-sentence investigation.
That's fine. Let's swear in Ms. Anthony, please. All right. Tell me your name, please.
Casey Marie Anthony.
All right. I have in front of me a plea form, and it appears to have your signature on the back of it. Is this your signature?
Yes.
All right. So you've signed this, correct?
Yes.
And you've also read it?
Yes.
Do you have any problems reading or writing English?
No.
So you read this and you understand it, correct?
Yes.
Correct?
Yes.
And you understand the rights that you're giving up by entering into this plea?
Yes, I do.
And you understand the defenses that you're waiving, which are listed on the plea form as well, correct?
Yes.
Most importantly, you're giving up the right to go to trial in this matter, and I'm sure counsel has explained that to you, correct?
Yes.
All right, and are you entering this plea freely and voluntarily?
Yes, I am.
What I mean by that is, has anybody forced you or coerced you into doing this?
No.
And you're represented by good lawyers. You're satisfied with their services, aren't you?
Yes.
Here today, are you thinking clearly?
Yes.
Are you under the influence of any drugs or alcohol?
No.
And you understand the minimum and maximum sentence associated with the offenses that you're charged with?
Yes.
And I don't know if this applies to you, but if you're not a U.S. citizen, this plea could result in your being deported. You understand that?
Yes.
All right. Mr. George, a factual basis, please.
Yes, sir. May I approach?
Yes, sir. This is the score sheet. Thank you, sir.
I've supplied a score sheet, a restitution order
Go ahead.
to the court. Your Honor, had this case gone to trial, the state would have been prepared to show that on July 8th of 2008, this defendant gave the victim, Amy Huizenga, a ride to the airport. In return, Ms. Huizenga had allowed the defendant to use her car while she was gone. The victim had inadvertently left her checkbook in that car. Had it gone to trial, all the following events occurred in Orange County, Florida. As to counts 2, 3, and 4, on July 8th of 2008, the defendant passed check number 142 in the amount of $111.01 drawn off the victim's account and used it at Target. As to count 2, relates to the defendant actually using the victim's personal identification without her consent. Count 3 reflects the defendant's making or actually forging the check. Count 4 reflects her actually passing the check at Target in exchange for merchandise. As to counts 5, 6, and 7, those events took place on July 10th of 2008. On those 3 counts, the defendant passed the victim's check number 143 in the amount of $137.77, also at Target. Count 5 refers to the defendant using the personal information of the victim without her consent. Count 6 is the defendant falsely making or forging the check. Count 7 reflects the defendant actually passing the check in exchange for goods at Target. As to counts 8, 9, and 10, those events took place within Orange County, Florida on July 10th of 2008. The defendant passed check number 144 in the amount of $155.47 at Target. Count 8 reflects the defendant using the personal identification of the victim without her consent. Count 9 is the unlawful making or altering or forging of the check. And count 10 reflects the defendant actually passing the check in return for merchandise, again at Target. Counts 11, 12, and 13 took place on July 15th of 2008, involves the victim's check number 146 in the amount of $250. Count 11 is, again, the defendant unlawfully using the personal identification of the victim without her permission. Count 12 involves the defendant falsely making or forging check number 146 with the intent to defraud. Count 13 reflects the defendant actually passing the check in the amount of $250 at the Bank of America. Going back to count 1, Judge, the state would be prepared to prove that the crimes already documented constituted one scheme or course of conduct to obtain the victim's money with the intent to permanently temporarily or permanently deprive the victim of over $300 in cash. That's what the state would be prepared to show.
Judge, as for the factual basis, the defense would stipulate for the purpose of the plea.
All right, thank you. And Ms. Anthony, do you understand if the case had gone to trial, that's what the state would expect to prove against you?
Yes.
All right. I find you to be alert and intelligent. The plea was freely and voluntarily entered into, and there is a sufficient factual basis for my acceptance of the plea. Either counsel want to be heard, then I'll hear from the state.
Yes, Judge. Are you referring to...
Just in terms of what you're looking
sentencing?
for. Yeah, a sentencing request.
Yes, Judge.
Karen, forgive me.
Sure.
Okay, thank you. I'm sorry. Go ahead.
No, Judge, I totally understand. As it relates to argument in this case, I think it's clear that our system, Judge, strives for the goal of trying to treat every single case differently and look at the individual facts, but at the same time treat every individual equally. And while it's a noble theory, I certainly don't think that it actually happens in every case, and it is our position that it certainly hasn't happened in this one. My role is obviously, it's that of an advocate, to be an advocate for Ms. Anthony and to ensure that she receives equal justice under the law. My colleague, Mr. George, certainly has a different role. As a minister of justice, they must apply justice equally. Now, it's our position throughout this case, or this specific case, that that has not occurred. However, if the state attorney of the Ninth Judicial Circuit will say that every person who takes a checkbook that's not theirs and writes a check, or writes several checks, 4 checks, totaling the amount of $654, that they would be charged with 13 felony counts in the counties of Osceola and Orange County, I would respectfully disagree. If the state attorney of the Ninth Judicial Circuit will argue that each person who does such an act will receive a plea offer of 5 years, I respectfully disagree. I think this case, and specifically Ms. Anthony, has had to endure somewhat of a situation of discrimination because she is an unpopular individual. And I think our system of justice and what we all strive here for is that everyone is treated equally, regardless of one's race, gender, or popularity. Now, 5 years in our position is extremely absurd. I could theoretically point a gun to someone's head, threaten to kill them, commit an overt act in furtherance of that threat, and still get less time in prison than what has been offered in this case. And then it takes us to you, where Your Honor is put in a unique situation. Your Honor does not have the ability to null pros cases where it may or may not feel that 13 counts would be justified, and puts the court in a unique situation. We simply ask that she receive equal justice under the law as what's written right up above you. And unfortunately, on certain circumstances, that just doesn't seem to work out when we have advocates on 2 sides of the room. Now, Mr. George is an excellent lawyer. He knows that I would make this argument. And I'm certain if he had the ability to search our entire public records and look for that one case where someone under similar circumstances has been charged with 13 felony counts for this specific act, or one that is similar, that it would have been brought before the court, or when I rest, that it will be presented to the court. But I don't think he can comply with such a challenge. And that, in turn, puts you in a unique situation. This case, anyone else, is pretrial diversion or a withhold of adjudication with probation. Because of Miss Anthony's status and her situation and her unpopularity, we all find ourselves in a muck of justice that I don't think, given the court the ability to dispense justice or ration justice the way it should, I think your hands are equally tied to a certain degree. But what we ask for is simply put, that she receive equal justice in this courtroom, and that the court say no to any type of discrimination that what we believe is actually occurring in this case, whether it's unpopular or not. And I know that we put the court in a difficult situation, but I'm quite certain that the court can see, based on what actually transpires in our system and on a daily basis, and what should be done in Miss Anthony's case. And for that, we ask that the court enter a withhold of adjudication on the counts and issue credit time served, and due to statutory requirements, give a short probationary period of approximately 1 year following any credit for time served that the court would give.
Okay, thank you. Anything else?
Actually, there is one other thing that I'm certain the court is aware of, and that is that Miss Anthony has no prior record of any kind, and she has made full restitution for these charges, and due to and righted any economic loss that may have occurred. We do have, for the record, an objection to the state's cost of investigation, where they're asking for $5,517.75 to investigate a crime of $600.54. We never asked that they send an armada of police cars to go pick Miss Anthony up after I had already volunteered to surrender her. What I would recommend the court do in this instance is defer this for a hearing after.
Well, here's what I have to do. I have to order the cost of investigation, and then if you dispute them, we can have a hearing at a later date. I don't know if you have any thoughts on that, but I understand you don't simply have to accept them. I'll order them, and we can fight over the amount if necessary later, okay?
Very well.
All right, Mr. George, go ahead, sir.
Your Honor, I don't know how long Mr. Bias has been practicing in Orange and Osceola County. I can assure him that the way that this case was charged and investigated is not uncommon. To file 13 felony counts off the number of checks that Ms. Anthony did forge and pass, it's not uncommon for our office to file it exactly as we have. That being said, and without getting into a competition of words here, Ms. Anthony has pled to all 13 counts. The state has not agreed, or never did agree, to drop any of the counts. That being the case, it's going to be the court's ultimate decision as to what the sentence would be. We would note that she has been in custody for over a year and a half, I believe. I would also state that, from what I can tell, all the restitution has been paid. The total that I had was $654.25. We may be off by a couple of cents here or there. It's my understanding that the Bank of America and thus Amy Huizenga have been made whole. The idea of withholding, Judge, would, I think, require, to make it a legal sentence, that the court place Ms. Anthony on some sort of period of probation. The state would object to that and at least recommend that the court adjudicate her on all 13 counts and give her a straight incarcerative sentence. There is no earthly point on putting Ms. Anthony on probation, which is in effect community supervision. She is being supervised 24 hours a day. She is in jail, and she will be so for the very foreseeable future and maybe for the rest of her life. The idea of putting her on community service seems counterintuitive. That being said, and with Ms. Anthony entering a plea to all 13 counts, we are asking for an adjudication on all and a straight incarcerative sentence. Your Honor, also I have provided the court with an order for blood specimen, which is statutory.
It's included in your packet.
It's included in the packet. It is statutory, and we'd ask you to enter that.
Thank you, sir. Anything else?
No, sir.
Quickly, anything else, Mr. Bryant?
Just as to the probation issue, Judge, I think the state puts the cart before the horse. We are working hard to acquit Ms. Anthony of her other charge, and I think it's a pretty bold foregone conclusion of the state to say that probation is an unnecessary or a redundant issue.
I wouldn't say it's all that bold.
I'm sorry. Did I interrupt you?
No, sir. That's fine.
All right. I have given this some thought, and I'm not exactly sure how to approach it, but I sat down and put together some thoughts this morning. And what we have here is 13 counts based upon 4 checks written on Ms. Huizenga's account, and here Ms. Anthony is charged with 3 offenses or crimes for each of the 4 checks, and then 1 additional count of grand theft, since the combined totals of all the checks are more than $300. And for each check written on the victim's account, Ms. Anthony was charged with, again, forgery of a check, uttering a forged check, and fraudulent use of personal identification. So she's charged with 13 separate crimes or offenses as a result of the 4 stolen checks. And previously, defense counsel has asked me to dismiss 9 of these counts for violations of double jeopardy, alleging that the defendant, in reality, only committed 4 offenses and should, therefore, only be sentenced for 4 offenses. Legally, I couldn't do this since each offense required proof of an element that the others did not. I didn't qualify for double jeopardy, at least in my view. In other words, each of the 13 crimes or counts contained independent elements of proof, so 13 counts are legally proper here. Even so, 13 separate distinct punishments and 13 separate adjudications of guilt don't seem entirely reasonable, since most of the counts or offenses are from, basically they're variants of the same core offense with the goal of punishing the same primary act, in other words, stealing somebody else's check. So multiple counts are proper, but multiple punishments, here 13, are generally, the multiple punishments would be unreasonable in this case for what is essentially 4, maybe 5 offenses. So what I'm going to do is this. I consider, at least in this matter, forgery of a check to be the primary offense. So on counts 3, 6, 9, and 12, those are the forgery counts. There is going to be an adjudication of guilt. Time served is 412 days, and I'll come back to court costs in a moment. Also, on count 2, that's fraudulent use of personal identification. There should be an adjudication of guilt on at least one of those counts, so I'm going to make it count 2. So on count 2, therefore, fraudulent use of personal identification, there will be an adjudication of guilt and 412 days time served. Finally, since the total of all the checks surpassed $300, which is the threshold for grand theft over petty theft, and it was pursuant to a course of conduct, I feel like there should be an adjudication of guilt as to the grand theft in count 1. Therefore, on count 1, there is an adjudication of guilt, 412 days time served, and that will be it. Now, these sentences that I just handed out cover the core offenses plus 2. That includes counts, again, 1, 2, 3, 6, 9, and 12. As for the 4 counts of uttering, uttering a forged check, which is simply handing the check over. Those are counts 4, 7, 10, and 13. And as to counts 5, 8, and 11, which are 3 of the 4 fraudulent use of personal identification counts, the court's going to withhold adjudication and sentence Ms. Anthony to time served, which again is 412 days, followed by 1 year of supervised probation, which is a little bit of a thorny issue based on what you've heard here today. I'm not normally in a habit of explaining a sentence to the public. We usually just rule and roll, but in this case, you should know that we can't put somebody on probation unless there's a period of we can't withhold adjudication unless there's a period of probation attached to it. So we don't know what the future holds here. If the state's correct, there will be a conviction and a lengthy prison sentence, or worse. If the defense is correct, there will be an acquittal and she'll walk free. So what I'm going to do on those counts that I'm ordering probation and giving her a withhold, again, that's counts 5, 8, 11, and 3 of the 4 fraudulent personal ID counts. There's going to be a withhold followed by a year of supervised probation. Once released, again, that's an issue here, with the following special conditions. First of all, no personal contact, direct or indirect, with the victim, Amy Huizenga, plus payment of court costs, which, Madam Clerk, I've forgotten. How much your court costs? $348. Plus payment of the costs of investigation. The amount the state is requesting is $5,517.75. The court's ordering payment of costs of investigation. If necessary, we can have a hearing on the reasonableness of that amount at a later date. My hope is that the parties can work something out or perhaps reduce it to a judgment or something. But I'm ordering it now. The court's also ordering on each and every count there has to be a blood sample, DNA sample that has to be gotten. And that will be it. Each of these sentences runs concurrently with one another and with any other sentence she may be serving, which of course is 0, since this was in essence the first offense. I've done what I thought is fair based on what I know. I understood your argument, Mr. Baez, about consecutive withholds since this was the first offense. As I said in the past, I just don't think I've ever given anybody 13 withholds. So what I've done here is there was not an even number of offenses, so I withheld in 7, I adjudicated in 6. If that seems Solomon-like, it is. I just couldn't think of a better, more appropriate way to do it. So that's the sentence in this matter. Ms. Anthony, you have 30 days to appeal this sentence. If you cannot afford a lawyer, we'll appoint one to represent you.
Judge, may I come in for a second?
Yeah, go ahead.
I was wanted to wait till you got done, but it's my understanding that I don't believe that you can have a period of probation to start at some indefinite time in the future.
Well, in other words, you're saying it's an indefinite sentence.
Yeah.
I may have to tweak it. I've been thinking about this, and I'm not sure how else to do it. I don't know that it's that indefinite because this is coming up, and it will not, the trial I'm speaking of is coming up within the period that I've got to work with. So, Mr. Ashton, did you want to be heard? Come into the podium if you want to speak.
I was just going to...
Please come on up to make sure we get this. Since it's within the 5 years that I've got to work with, I think I'm okay. Tell me if you think... Mr. George, go ahead.
Well, Mr. Ashton was suggesting, and I have not heard of this, but I suppose it can be done. Probation could start today. She would just do the probation while incarcerated in the Orange County Jail.
I have a note from my clerk. 1 second.
Everyone's chipping in, Judge.
This is unrelated. I forgot. I ordered cost of investigation. Is there also cost of prosecution?
I don't know what that amount is, Judge.
I'll order it and reserve on amount. Again, you're not locked into any amount. We can always disagree later as to the amount.
We could solve this issue with a reasonable bond, Judge.
Hold on. Anything else?
No, Judge, I guess it would be problematic, but she can be
I
supervised.
can order jail as a condition of probation. Again, I'm not sure of the propriety of doing that. My problem is her jail time. She's exceeded the 1 year in county jail that we're allowed to sentence somebody to. The reason I didn't do it that way is generally, as you know, we can't sentence somebody to more than a year in the county jail, and this would be doing that. I'm willing to reconsider it and modify the sentence if there's a better way of doing this. I think everybody's goal is the same. And Mr. Baez, anything else from you on that?
No, Judge. Actually, Ms. Anthony does want to inform the court of
All right, that's fine. And also, forgive me, I forgot. I normally ask and simply forgot. I didn't know if the victim wanted to speak or if she was even present. Mr. George?
No, Your Honor. I've spoken with Ms. Huizinga. She was aware of potentially what was going to happen today.
Okay.
She understood it. She did not wish to be present and did not wish to speak.
That's fine. Let me just, I've kind of struggled with the probationary issue, and I'll give this some thought. If either one of you want to submit something that you think might be better or more realistic, let me know, and I'll certainly consider it. Again, I don't think it's so indefinite as to be illegal, but I get your point. If you think there's a more proper way, just let me know. We can reconvene in short order. Mr. Baez or Ms. Anthony, go ahead.
If Ms. Anthony would like to
Please,
tell the court something.
The floor is yours. Go ahead.
I just wanted to let everyone know that I'm sorry for what I did. I take complete and full responsibility for my actions. And I'd like to sincerely apologize to Amy. I wish I would have been a better friend.
Okay, thank you. Anything else?
No.
All right. I thank you. Once again, you have 30 days to appeal the sentence, and if you cannot afford a lawyer, we'll appoint one to represent you. At this point, I think you can have a seat, and we'll, deputies, you're good? Okay, that's fine. Have a seat if you would, and then I think we have, I guess, 2 motions. And Madam Clerk, I think I did order the cost of prosecution. I just don't know what they are, so I'm reserving, and we'll deal with it later. Also, I've got the score sheet, and for the record, she did not score prison. I've signed the score sheet. The DNA order is here, and Madam Clerk, I'll pass that along to you. Yeah, also, excuse me, there's the plea form. Why don't we talk about the motion to take the deposition to perpetuate the testimony of Jill Curley. I'm not sure we're all that far apart in this, but Ms. Lyon, did you want to argue?